Never thought I'd see a federal court order that essentially refers to an administration and the DOJ as idiots. But this is about the closest you come to a federal judge saying, are you a bunch of idiots? Do you not know how to read my prior orders? Do you want me to restate what's in my prior orders? Let me tell you what just went down as Judge Colleen Kolar-Cottley issued an order saying, let me remind you one more time. You do not have a right to look at the records that you're claiming you need an extension of time to look at. So before Christmas and before New Year's, the Trump regime filed an emergency motion and they said, Judge, we don't have the technical capabilities in the Washington, D.C. and surrounding area at the DOJ to comply with your prior order that says we needed to turn over the attorney-client privilege file of Daniel Richman. Richman was James Comey's lawyer. The DOJ tried to launder attorney-client privilege communications between Richman and James Comey through an FBI agent who should not have seen those records because it was not done through an actual warrant. It was an unlawful search and seizure that took place. But Lindsay Halligan, Trump's stooge, who we put there as the United States Attorney for the Eastern District of Virginia before she was disqualified, even though she still pretends to be a United States Attorney from the Eastern District of Virginia. To this day, they tried to bring on this FBI agent to testify about attorney-client privilege information. Now, the case against Comey got dismissed for other reasons because she was disqualified and there was nobody else in the room or who signed on to this completely corrupt indictment. But thereafter, Daniel Richman filed a lawsuit against the government for unlawful searches and seizures, violation of his constitutional rights. This judge, Judge Colleen Kolar-Cottley, made a very clear order. DOJ, you can't read or look at these documents. You didn't have the right to them. Okay, you need a warrant to look at them. There's one document which you can delete, but you can't look at it. You can delete one classified record. Don't look at it. The rest, delete from your files, turn it over to Comey's lawyer, Daniel Richman, and you can lodge another copy of it with the Eastern District of Virginia. And if you want to go about getting a warrant, go get a warrant, and then you can ask the magistrate judge there to then give you the files. But you have to show probable cause about why you need this file. You can't just go through it. So the Trump regime, right before the deadline, they go, emergency motion. We don't have the technical capabilities to go through it. Judge, pretty please, can we go January 4th or 5th? Please. We need we can't look through these documents. And so the judge gave this order and the judge is like, look, here was the judge's order a day or two ago. The judge is like, okay, you want until the 5th? I'll give you until January 5th to produce these things. But what are you talking about? You realize the whole purpose of my order is that you can't look at these documents. You don't have the right. There's no warrant. So the judge is like, I don't know what it is that you are reviewing because you're not allowed to review anything. The order was turn it over, press delete, and then you can lodge a copy in the Eastern District of Virginia if you want until you get a warrant. So the judge says, let me reiterate it again. You can't look through these documents, but I'll give you until the 5th. Again, it's just a humiliating order right here. So the court says the court's in receipt of the government's emergency motion for extension of time to certify the compliance. And the court says, given the holidays, the court will grant the government's request to extend the deadline to certify compliance with the court's December 12, 2025 order as modified and clarified by subsequent orders. However, the government's motion appears to request permission to search petitioner Richman's materials for classified materials without first obtaining a valid search warrant, which would be in direct contravention of the court's orders. Accordingly, because the court has already ordered that the government may not search petitioner Richman's material to identify additional classified information without first obtaining a valid search warrant, the court shall deny the government's request to do so. To ensure the government understands its obligations under the court's prior orders, regarding the deletion of classified information, the court shall take the remainder of this order to re-emphasize those obligations. Let me bring in Harry Litman from the Talking Feds YouTube channel, the Talking Feds podcast, and the Talking Feds Substack. This is like talking to a law student who is failing and not even trying. And it's the dean telling the failing law student, let me reiterate the standards of this law school because you're about to fail out of it. And I'm trying to explain what your obligations are. It's even worse than that.
I was going to say,
example I can give is whatever the hell this is. Yeah. This is not normal that the judge has to lecture the DOJ about what its orders say. Harry, what's going on here?
Yeah. So, I mean, it's nice to, it's more like talking to a brick wall. Remember what's happening here, Ben. These are the materials that we already know they shouldn't be using, and yet they put in the grand jury an agent who had reviewed them improperly, and that's one of the reasons that the Comey indictment is so imperiled. By the way, who signs this actual motion? Pretty interesting. Todd Blanche, the Deputy Attorney General, Lindsay Halligan, your guess is as good as mine, but the something, and Robert McBride, the first assistant there. They're trying to cover tracks, but also trying to sort of keep with Halligan. That's the theme, by the way, of this whole thing. They just don't listen and try to do ends around every single order. But the whole problem, the reason they ordered it returned in the first place, they get a subpoena in 2007, and it has a certain purpose. You can't just, under the Fourth Amendment, we got something, 5 years ago for one purpose, and now, I think it's in the file somewhere. You need to have probable cause and justification when you're investigating a crime that the evidence you've seized will be fruits of the crime, et cetera, et cetera. So it's completely improper, any kind of, and Richmond says it was always improper, but it doesn't matter because they can't be using it now. That was made so clear. And in fact, that when the witness, FBI agent, went in and testified, that's going to be a whole nother problem if it's not dismissed for selective prosecution. But they do it anyway. And then the brazenness of the actual motion. What they say in emergency is they need to sift through everything to see what is possibly privileged and classified and the like. No. You don't have a right to this stuff. You have to just delete it. That's the order. You've identified one classified document you're worried about returning to Richmond. Fine. Look on the bait stamp or the numbers and handle that separately. But I never gave you, and the Constitution precludes your having some kind of general warrant to just sift through all this stuff. That's why, and we talked about this last week, Ben, that's why oh no, we don't have enough time. You've got a chunk of stuff that Richmond turns over. You do this or maybe this. That's how you delete it. It's not like it's far flung throughout the government files and the like. And why is it difficult? Because they're trying to push against the judge's order. They're trying to do more with it, use it, scrutinize it, precisely what they're not allowed to do, and what they also did to indict him in the first place. So, this law student might eventually, after 3 times, the message might stay in your head, but that's not who these guys are. It's just like, did you not hear the words I just said a week ago? You are the Department of Justice. Normally, an order is something that you receive and discharge. So again, we've talked in all these cases, there's some combination of sloppiness and purposeful obtuseness. And, either of those is a reason for her to say, give me a break. What are you trying to do here? But the fact that, it's sort of partakes of both, that's where we, and that Todd Blanche is involved, that's where we are. with this Department of Justice. You know, this is Richmond. That means it's Comey and no holds barred to try to get at him. And even though they say this evidence is all off limits, they're not taking no for an answer. And that's, of course, what the Department of Justice does when judges say, no, you take no for an answer, not these guys.
Harry, judges talk.
Among themselves. Yeah.
They go to lunch with each other. They go to dinner with each other. They attend conventions. They have clubs. They hang out in different groups. There are cliques there. There are formal associations, informal associations. Judges talk. Who are the good lawyers? Who are the bad lawyers? The good firms, the bad firms. The DOJ reputation that's out there right now amongst the judges at the rank and file federal judge, trial court, and by and large, court of appeals is that these are a bunch of clowns, that the good people left. And there's still, here's how I hear it from certain people. There are still a limited amount of cases, small, where there is some talent at the DOJ who can handle a super high profile case and they're just hanging on for dear life. But that's a very rare thing, that by and large, this DOJ is viewed by judges across the board as just being the worst. And that when you show up as the DOJ, it's what are you hiding? What are you trying to pull? What are you lying about? And when we report on this, trust me, the judges, if Harry and Ben are having these conversations, the judges are talking about this stuff right here. And they're saying, could you believe that they asked me that they didn't have the technical capabilities and they begged me for an extension? Oh yeah. I'm having the same issue here too. They came in front of my court and didn't produce discovery. Oh yeah. Could you believe? This is happening every day. I'll give you the final word, Harry.
And nowhere more than the district court for the District of Columbia. Judge Cutter Catelli is 82 years old, initially appointed by Reagan, then Clinton to the district court. She's a dean, well-respected, well-liked, who's seen it all. But we've made this point again and again with Boasberg's refusing to let go of the original contempt because he is the chief judge, and I think he sees himself as representing the whole bench. And who is his bench? People who spent 3 years of their lives adjudicating absolutely righteous cases of marauders and insurrectionists, not a single one of which was acquitted, and everyone who either pleaded guilty or went to trial and was convicted, only to have all that work just wiped out in a stroke of the pen in a couple hours after Trump takes office. That and many other cases which first get filed there, they've really seen up close it's not just the sloppiness and the good people having left, it's the absolute corruption of the Department of Justice. And by the way, several of them, Judge Boasberg, he was a prosecutor for many years. Judge Cooper, he was in the Department of Justice in Jamie Gorelick's office. I mean, these are people who know the DOJ, understand just how corrupt and defiled it is being, and they clearly talk among themselves. We knew this back when Trump was a criminal defendant, and it was clear that the judges were collaborating. And I can just say, without talking too much out of school, that what you say is 100% true. They not only talk, but are appalled by not just the level of practice, but the politicization and complete capture and denigration of the Department of Justice that, has always been the same for Catelli from Reagan to the present until now, when we have just signal corruption and evisceration of everything the department has stood for a generation.
Everybody, make sure you subscribe to Harry Litman's YouTube channel. It's called Talking Feds. It's where I get my legal news from. He also runs the Talking Feds podcast on audio podcast platforms and the Talking Feds Substack. Subscribe across the board to Harry Litman's platforms. Talking Feds by Harry Litman. Thanks, Harry.
Thank you, Ben.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.